You're on the Legal AF MTN network, and this is unprecedented. We're talking about the United States Supreme Court, start of its 2024-2025 term. We're going to cover it all, the second week of cases being heard, new decisions coming out, new oral arguments, things that are that are coming up in the future that we want you to know about at the intersection of law and politics. And I'm here every week with Dina Dahl. Dina, great to see you again.
Great to see you too. Looking forward to it. We got some good things here.
Yeah, we got three major cases we want to talk about. We're going to cover all the things that are important to our audience. Take a moment, hit that subscribe button. Early voting has started. Vote for Legal AF MTN by hitting the subscribe button. We're already at 220,000 subscribers on our 30th day in existence, and that's all because of the Legal AFers and Midas Mighty and other people that have found our content here. And we're glad that you're here for one of our unique exclusively on Legal AF MTN shows, unprecedented. We're going to talk about the First Amendment and the attempt by Texas police in Laredo, Texas, the police officers there, to jail a reporter because they didn't like her reporting about them and what the United States Supreme Court has done about that. Does the First Amendment trump qualified immunity that's usually given to police officers about suits about their actions or not? Or does the First Amendment mean what it says, that it's the First Amendment and it needs to be protected? We're going to talk about that. Then, of course, we've got another gun case because this Supreme Court can't help themselves but to keep talking about the Second Amendment. For them, the Second Amendment is the First Amendment. It's the one that's the most important. And we've got a new decision related to whether 18 to 20-year-olds can be denied the right, I guess, the constitutional right to carry a gun or not. And the Supreme Court has something to say about that. And this term, there's going to be a series of cases that stands on the shoulders of a bunch of cases from last year in which they single-handedly destroyed the administrative state and destroyed the role of administrative agencies like the Environmental Protection Agency to protect our water, to protect our air through proper regulation, through fines, through penalties, through a internal administrative process. Having ripped that all away last term, now they're putting on their napkin, Dina, around their neck and their knife and fork. And now the Supreme Court and the MAGA on there are ready to talk about not one, not two, but five different EPA, Environmental Protection Agency regulations. We got a new one up here that we're going to start it off with and then talk about the cases that are going to be considered this coming term. All on, what is it? Everybody say it with me, unprecedented. Let's kick it off with the uh, I love this reporter for many ways. She is a renegade. She is doing guerrilla reporting. Her newspaper is a Facebook page. Her name is Priscilla Villarreal. She's on social media. You can find her. We're going to post it there. And she took a case to the United States Supreme Court. She's also known, we're not naming her. This is her name for herself. She's known as LaGordiLoca, which if you look it up has a meaning, but this is what she calls herself. She said she's loud, she's brash, she's vulgar, and she's doing investigative reporting and is the number one journalist in Laredo, Texas. And what did the Supreme Court have to say about a case in which she sued the Laredo Police Department?
So what happened? As you said, she is a citizen journalist, was known to kind of ruffle the feathers of the law enforcement there because she was willing to speak truth to power. And she had reported on two instances that was came upon this case here. A Border Patrol agent who had committed suicide and a fatal traffic accident. And she had gotten confirmation on these stories from a law enforcement officer there in Laredo, Texas. She published the stories. Well, sure enough, they were upset about this. The police department there, the law enforcement were upset about this. And they used a law on the books. It had been on the books for 23 years and had never been used before. But sure enough, they used it against her. It was they arrested her for a felony. For the statute had said it was a felony to obtain information from a government official to use it for your benefit. This was what they arrested her for. And essentially a local judge there thankfully dismissed the charges, but then she sued the police department for violating her First Amendment, her Fourth Amendment, and her 14th Amendment rights. And they asserted qualified immunity, which essentially gives immunity to the law enforcement unless specific constitution rights are violated. And the question then was, did they violate essentially her First Amendment rights? And interestingly enough, when it first got onto the Fifth Circuit, it was a Trump appointed judge who sided with her, which, you think that like that never happens. But he kind of pointed out, if you really are going to say that a reporter, cannot get a report on information from the government, if you're going to protect them and be able to like arrest reporters for essentially just reporting on what the government has done, like this is a mockery of our First Amendment. But the entire panel of the Fifth Circuit then reviewed it, disagreed with him. They, because the Fifth Circuit, ultra conservative, as we know, sided with the police department. It went up to the Supreme Court, and the Supreme Court didn't have like a full hearing. It was essentially they overturned that Fifth Circuit decision, the larger Fifth Circuit decision that sided with the police department and said that essentially no, like they do not have qualified immunity in this situation, and sending it back to the lower courts to review it again based on this decision. But I cannot think of a case that's like more important in this day and age where we have Trump and Vance willing to lie about every little last thing, and to have this situation where they were trying to arrest a reporter for reporting on what police officers were doing, and then using the qualified immunity as a protection is like a really scary thing in this day and age. The Supreme Court did the right thing in this situation, but who knows if this is going to come up again. But that poor woman, like really going through it there. What did you think about that, Popok?
Yeah, she's an intrepid reporter. We should give her our support. We're going to put up her Instagram. She goes under Priscilla Villarreal Trevino. And we also have her Twitter feed. She needs more followers. She's running this Laredo news from the back of her car, and from her Facebook page. She goes. You'll see how she writes about herself, and she's intrepid. She takes on police, corrupt police, border patrol officers, and the like. And she's exactly what the First Amendment was invented to protect. In fact, the judge of the 3-judge panel who wrote the decision that was overturned by the en banc panel, is Judge Ho, and we did a whole thing with court accountability recently about Judge Ho because he's MAGA to the bone. He was sworn in for his Fifth Circuit role by Clarence Thomas, who he clerked with in the home of Harlan Crow, the corrupt Republican MAGA donor, Nazi memorabilia. That was done in front of his fireplace in his lodge. So even if James Ho found this to be a violation of the First Amendment, that's saying something, because he's trying out for the United States Supreme Court should there be another role. But it doesn't surprise me that the Fifth Circuit once again gave a case to the United States Supreme Court. The largest number of cases coming out of the 13 different federal circuits and districts that come up to the United States Supreme Court, the number one is the Fifth Circuit Court of Appeals. And when you have a 9-7, we had 16 people who heard the case en banc. Picture this for our audience. When you ask for an en banc review, you have to have at least the majority that's interested in hearing the case. Normally, you just get your 3-judge panel. So that's how most justice gets done in this country. 3-judge appellate panels, randomly selected, usually. But if you don't, that's at the federal level. If you don't like it, you can ask for an en banc review. And if you get enough votes where they say, yeah, that's interesting, then it'll come up en banc. And en banc means all the rows of seats are filled with judges. Depends on how many are in your circuit. In the Fifth Circuit, apparently there were 16 seats. And then majority wins. So the majority was a 9-7, talking about a close call, 9-7, that overturned the original decision by Judge Ho and found that qualified immunity overcame the First Amendment and protected the police over the rights of the reporter. And so, as you said, the Supreme Court was like, yeah, no, we're rejecting that. Go back and do it again under these terms. So I think here we'll ultimately have a victory for the First Amendment. And again, a shout out. And anytime, Priscilla, Priscilla Villarreal, LaGordiLoca, you want to come on unprecedented or any part of Legal AF MTN? We're extending an invitation. We'll try to reach out to her and see if we can get her on here for an interview because I think that would be fascinating. Let's switch gears and talk about guns. Not because I want to with you, because apparently we have to. Why don't you update everybody about sort of where this Supreme Court seems to be in the line, drawing the line about gun rights, and why this case, what happened in this case, and why it's not the end of this case.
Well, I mean, I think kind of like what we saw with the Trump immunity decision in the summer. They wrote a really vague uh, new law with the Bruin decision saying that any gun restrictions have to have a basis in history. And of course, our guns were not even close. So you don't have a lot of historical precedent that you can look to. And this is really confusing. It's really confusing to courts, to states, and the Supreme Court is basically having to grapple with the aftermath of putting forward a really broad but yet vague decision. And so what happened was Pennsylvania passed a law that said that 18 to 21-year-olds were not allowed to carry firearms during periods of declared emergency situations. And interestingly, that would have actually helped in the, Kyle Rittenhouse case, right? He was able to legally have that firearm because it was a hunting rifle, and he used self defense. So this kind of law in Pennsylvania kind of helps give that a crime in itself is carrying a weapon for those 18 to 21-year olds during those kind of declared emergency times. But of course that was sued like this is, there isn't a historical precedent for this. The rights, you're infringing on the rights of these 18 to 21-year-olds. The same argument we are hearing over and over from people who want there to be basically like unfettered access to guns in America. So the Supreme Court, though, in this situation, did not reversed the lower court, who said that the ban on 1821s carrying the gun was unconstitutional, reversed that. So basically siding with people here who wanted to regulate the 18 to 21-year-olds. Reversed it and asked the lower courts to review the decision again in light of their most recent gun decisions. So story continues on that one.
Yeah, I'm gonna manage expectations here based on
Mhm.
cases that are similar that came out of Texas. I think this United States Supreme Court is going to find that regulation preventing an 18 to 20-year-old carrying a weapon are unconstitutional. I would be shocked if after they get this case back, if they were declare that I don't think they're going to find that historical antecedent
Mhm. Mhm.
back in the 1880s or old timey or 1790s, whatever the period is, just because the reality is that until more modern era, everybody carried a gun. Women were owned property by their husbands. That's why this whole historical antecedent thing has a tremendous dark side to it because it doesn't respect that many things in society as they are now were not treated that way then.
Mhm.
Black Americans were slaves, women were chattel and property, so were blacks. For us to then say, but we like their gun policies. Uh, you that's why they struggled with the domestic violence case related to should we allow this person that's got a restraining order against him for beating up his girlfriend? Well, let's look at old timey times. Well, old
Yeah.
timey times, women could be murdered by their husbands and not suffer any consequences.
Mhm. Yeah,
So
exactly.
I don't really understand how this is helping us with a modern appropriate regulation of the right to bear arms. There's a good reason, 18 to 20-year-olds brains aren't properly formed yet. Now, the counter argument is, well, they're holding weapons of war in the military.
Mhm.
So why can't they have one for self-defense? And that is where I think the Supreme Court's going to come down. If they can vote and they can go to war, they can have a gun for self-protection. I'd be shocked, frankly, not because it's right, just because I'm just being predictive off of what I know. If they came down and said, yeah, 18 to 20, sure, no. I mean, maybe 14-year-olds, maybe 15, maybe they'll think minors with malformed brains. But they're going to. That's why one of the things I want to do on the show with you is sort of manage expectations. What looks to be a slight win,
Mhm.
or because we're going to talk about the EPA case next. And it looks on paper to be a slight win. Like when I saw the headline, I was like, that's weird. This Supreme Court is siding with the EPA about regulating carbon emission or something like that. That sounds weird. And then when you really dig into it, which is what we're going to do here, you're like, oh, that's not of a good as a result as I thought it was going to be.
Mhm.
And we'll talk about that next. Anything else on the gun case? Then we'll turn it over. We'll start bouncing it around on the EPA ruling.
No, I think, like you said, we're really discussing it in the middle of the
Yeah.
process. And it is, there wasn't as if there was an order that talked about how the justices really felt about this issue. It was just they felt like that particular judgment wasn't in line with the law that they had already created,
Yeah.
but that didn't mean that eh, as it changes on the lower court, they may take it up again and, as you say, like, gut it.
Yeah.
So
Well, yeah,
that's why
yeah,
we keep talking on it.
yeah. On our viewers and listeners, it is not uncommon for an appellate court or a Supreme Court to remand or send back a case to the lower court, the trial court, with instructions on what to do. Hey, it looks like you missed analyzing it under the state constitution, or hey, it looks like you missed our most recent precedent. How does that
Mhm.
map onto your decision making now that we're telling you to do that? It may end up in the same place,
Right.
or they might, by the trial judge, they might say, well, yeah, okay, or they might say, oh, well, under this and the analysis there, then we think. But this is them telling them without rule, because remember, when I say remember, that's just a shorthand way for me to transition my thought. Nobody has to remember it. That's why we're doing YouTube. But but the Supreme Court is a court of last resort, and it's not a trial court level. It has to make its decisions based on a factual record developed at the trial court level below. So some people might be thinking, well, just skip a step, just make the ruling. You know where this is going, Popok, for the Supreme Court. And they may well know where it's going, but it has to still jump through all of these procedural hoops in developing the record. Now, sometimes when this United States Supreme Court is impatient and wants to set new law, it ignores the record. It actually says out loud in oral argument, let's not get bogged down in the facts. When you hear this Supreme Court during oral argument, and we'll do some of them here on Unprecedented, say, let's not get bogged down in the facts, run for the exits, because that means they're going to start legislating from the bench, creating new law that's untethered to the Constitution or to any act of Congress. They're just going to make it up. That's what.
Mhm.
Let's not talk about the facts because they're very confusing or they're very unique. Like, yeah, well, you're an appellate court. You're supposed to be talking about the facts on appeal. So
Mhm.
that's a little trick of the United States Supreme Court and the MAGA alt right on there
Mhm.
that we're continuing to follow. That's a good segue into the EPA. Let me preface it by saying that last term, the on the checklist, on the Christmas list of things that the Federalist Society and the alt right have wanted to accomplish once they got the numbers on the United States Supreme Court. If you were to look at the list that Leonard Leo carries around in his back pocket, it says destroy a woman's right to choose enshrined in the Constitution in Roe versus overturn Roe versus Wade. Okay, put a big green check next to that. They did that. Second is anything related to the administrative state, which to describe that quickly to our audience, Congress passes a law. Sometimes it's a page, sometimes it's a 500 pages. But for the nitty gritty of how to implement that law or how to implement the rest of our regulations, the regulations are not made by Congress and 528 members of Congress. The regulations are delegated over to an administrative agency that's responsible and expert in that area, who then passes regulations after public comment, and then they put with industry input, and then they put together the regulations, and that's published in what we call the Code of Federal Regulation, the CFR. That's not for Congress people, that's off a delegation. And the Supreme Court and MAGA right have hated the delegation to administrative agencies and the rise of what they see as an out of control administrative state that's not helping people, but hurting business and hurting whatever they're hurting. So they've tried to dismantle the administrative state, or what they call the administrative state. And one of the things they've been attacking is laws created in violation of what they think is the Administrative Procedures Act, the APA, which is created by Congress. Oh, you violated the APA, Environmental Protection Agency or Department of Justice or this or that. You didn't do it right. You didn't jump through this hoop or whatever. And they try to strike the thing down related to that. And then they got rid of all the ways, the mechanism by which regulators have been fining and assessing penalties and then enforcing those through administrative law judges within the agency itself. That got dismantled last year. And then finally they've hated, Leonard Leo has hated what's called Chevron deference, which is what you and I learned in law school, which is you leave it to the experts, you give them the benefit of the doubt in the actual administrative area, and the judge should defer unless it's completely crazy, defer to the position taken by the administrative agency and their experts. Like they know more about clean water and clean air than some judge who failed biology in high school. And so it was called giving deference to the agency. That got completely ripped out of the books after 50 years. And no longer, now the opposite. Supreme Court told federal judges, that's your job. You come up with whether this clean water, clean air issue is right or wrong. You don't listen to the experts. You don't defer to them. You make the decision. Because why? Because they got MAGA judges and Trumper judges who are going to side with big oil, big business, big fossil fuels. So that was last term. Now we got a whole bunch of cases this term in which they're going to go after each one of these agencies, starting with the Environmental Protection Agency, which has been a thorn in the side of big business and big oil and big fossil fuel forever. So what's the new ruling that we just found out about this week?
Yes. And, to your point about that, Project 2025 is trying to do it on the other end. They're trying to get employees in these agencies who will not even implement the rules already in place or write new rules in order to enforce it. So that's kind of the bookend. Project 2025, they're trying to take away the enforcement of these laws. And then you have Leonard Leo trying to do that through the courts. They're both trying to do the same thing, but two different ways. And so in this EPA ruling, they basically, EPA was trying to do was to decrease emissions. And I wrote this down because it's stunning how much this rule would be helpful for our air to be clean. That for the next 20 years, this rule in place for the next 20 years would prevent the annual emission of 328 million gasoline cars and provide 400 billion in benefits to the climate and public health. Like a massive um, uh, rule benefiting us. And basically what they wanted to do is this is, they have contested this rule, and they want it to, say that this was exceeding the authority of the EPA. And they asked the Supreme Court to basically block the rule while the challenge went through the courts, because the challenge can take several years. We all know, through Trump's thing, how long our justice system can take. The challenge could take several years. The Supreme Court said, no, we're not going to block this EPA rule. We'll wait and see once it actually comes in front of us, and then we will make a decision on it. But we'll let this rule stand. And to your point, there's already several other EPA rules having to do with mercury, having to do with methane, that they have also asked the Supreme Court to block as it goes through the courts. And the Supreme Court has said in those situations also, we're not going to block it. But that just means like the rules in place until they go to here. Interestingly, with this order, we did get a sense of where some of the justices lie. And another interesting thing, talking about ethics, Justice Alito did not participate in this order. He owns stock in one of the companies. So we'll see, does he actually recuse himself in this case? He didn't participate in this order. We know that Thomas said he would have blocked the rule, shocker, and Kavanaugh and Gorsuch would have they agreed with not blocking it, but they thought that it was likely that this there would be success on the merits. So we know that Kavanaugh, Thomas, and Gorsuch will want to permanently block this law once it comes in front of them. And really, the question will become, what does Chief Justice Roberts and Justice Amy Coney Barrett decide when this finally comes in front of it? So we got a little bit more of a glean of where the justices lie on here.
Yeah. It's the Amy Coney Barrett court this term because if she votes with the reasonable wing of the Supreme Court, it'll get it'll be allowed to stay in place. And if she doesn't, Roberts has no he's such a weather vane. He just goes wherever MAGA goes at this point. So my eyes are on Amy Coney Barrett for the term. I think she's going to be instrumental in a number of cases that are going to be pro democracy and pro environment at this point. They the way the Supreme Court decides the cases that they're going to hear. They end up hearing about 70 cases during the year. They've got about 24, 25, or 26 already scheduled. They haven't scheduled any new ones yet, but by the time the year is over, they'll fill their plate. They'll fill that class with about 70. They hold at the beginning, right before the first Monday in October. They get together on the 30th of September in what's called the Long Conference, and they look at the list from prior and from current. It's called the relist, and they decide what they want to hear. And on the relist they did on September the 30th, they listed 14 cases that are interesting to them. Three of them are about the EPA and regulations. Well, sure, now that they've ripped away the Chevron deference and the administrative state, sure, let's now go after the administrative agency. One is about the separation of powers, which also concerns me, and another is about an equal protection challenge to facially race neutral admissions policies for public schools, where Asian Americans are claiming they're being used to keep Asian American kids out in large numbers from some public schools. And we know what the Supreme Court did with affirmative action and dismantling it at the university level, the college level, and Lord knows what they're going to do now at the public school level. So those are things for us to continue to look forward to. But this is rather than do it quarterly or like the end of the year wrap up, we're doing this weekly. And so when there's an oral argument that we think is interesting, even I'll tell you what we'll start doing is when we hear an oral argument that's interesting, we'll play a snippet of it here so you get a little sense of what these oral arguments are like. And if it's really important, we'll play the oral argument and we'll do some commentary, like a little bit of a post game show, like we've done in the past, right?
Absolutely. You can get so much just from by the oral argument.
Oh yeah,
You basically knew how they were going to decide when you and I analyzed the cases
oh
in the
yeah.
spring resulting Trump. So it's like a real live. And when everyone else hears the questions too, yeah, they're fascinating. So that'll be great.
Having been an appellate advocate in the past, in most courts, you I mean, sometimes I knew when I won or I lost, but in a lot of appellate courts, state or federal, you know, uh,
Mhm.
it's hard to tell. I've walked out of appellate arguments grabbing my backside, making sure it was still there. And then I get home, and a week later, or no, not a week later, a month later, I get the order and I won. I'm like, I won that one. And other ones, I'm like, oh, I got them eating out of my hands. This is amazing. This is going to be so great. And then, a month later, like, I lost. So, but the Supreme Court, because of the personalities and the audiences that they're promote, that they're performing in front of, what you see is what you get. I mean, if you see a troubled judge, they're going to be a troubled judge at the time they're writing. If you
Yeah.
see I always know when Roberts is going to take control over something because he'll ask like one withering question, and I'm like, oh, he's going to be writing this one. Like when I'll give you an example. When they were doing ghost guns that you and I reported on last episode of Unprecedented, uh, Roberts had already been in favor of regulating guns that you create at home from a kit. like a Holly Homemaker. You just make like the bake oven. What do you call it? What was that oven? That little oven with the light bulb that made brownies when we were kids that you had. Did you have one of these?
I didn't,
Easy.
but I know
You
what you're
didn't have it.
talking about.
You didn't have an easy bake oven.
Easy bake. I did not.
They
I had
probably are.
friends who had it.
This is probably you probably could burn your house down, but it was a very hot light bulb, and they gave you some little crappy brownie mix. You can write to us if you know what I'm talking about. And you had a little tiny pan, and my we made it, and then you shoved it into this little pink oven, and then you turned it on, and it made it. It was, and you made a brownie, and so Ghost guns is the same thing, except instead of a brownie, you're making a gun at home with a plan that's not registered, and or a 3D printer, worse, where you're making the parts and the regulators don't know anything about it. That sounds like a bad thing. And so
Yes.
when Chief Justice Roberts was asking he had the best question, and I knew he's going to write this order, and he said he stopped the advocate for Paul Clement. He's always the advocate for the gun lobby, and he said, I just have one question. So are you telling me that we can regulate the gun and ask for it to be registered, background checks and everything, but we can't regulate the kit that was used to build it? He said yes. He's
Mhm.
like, all right, thank you. And I'm like, oh, that's it. We're done. We're
Yeah,
done. One question. That's all you
thankfully.
needed. Yeah, he's good that way. But listen, this is unprecedented. We named it for a reason. You're here on Legal AF MTN. Help us build this pro democracy network. We're not resting on our laurels. We're at 220,000 plus. We want to get to 500,000 for the beginning of the year. It's not our ego. It's the bigger this pro democracy channel is built in collaboration with the Midas Touch Network at the intersection of law and politics, the more your voice is heard. And we just think that there is no other I'm sorry, I'll just say it out loud. There's no other commentary at the intersection of law and politics and than what we're doing here on Legal AF and on a show like Unprecedented. And I thank you for being here. And if you already subscribed, really a personal shout out and thank you to you. And if you haven't yet, hit that oval button. So until next week, right here, Legal AF MTN, you got Dina Dahl, you got Michael Popok. Shout out to the Midas Mighty and the Legal AFers. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.